I do believe I am live. So welcome everyone once again to Facebook, to YouTube, to wherever device you're using to see me today. My name is Lior Samfiru. They call me the employment lawyer, and I'm here to talk about employment law. One day I'll log in here, we'll talk some basketball or football or baseball, but not today. Today we're talking about employment law, about workplace rights. We do this session every week to allow you to ask questions, to allow you to find out information that you need to have about your workplace rights. This information is not just something that you can Google. You can't Google an answer to your specific scenario, to your specific problem, but I can answer your specific issue. So this is live, I'm live, you're live, and I'm here live because I want to take your questions. So whether you're struggling now because your boss is not treating you properly, maybe your job has changed, they've reduced your hours or changed your responsibilities. Maybe you were given some sort of an ultimatum, maybe about vaccines. You have to get vaccinated or else. Any issue, whatever that issue is, call or not. You don't even need to call. You just type in your question right now. I'll see it and I'll answer it. I know a lot of people right now are on a layoff. You haven't been working for a while. You want to know how long you can stay on the layoff. You want to know what your rights are, what you're owed. Well, no need to wonder anymore. That's why I'm here to answer those questions. Ask them. Don't be bashful. There's people watching, and when you ask your question, you'll be helping others as well find out the information that they need about their rights. So not only are you helping yourself, you're going to be helping many others that are watching today. Now, let me give you some other information before we get started. If you want to have a private chat with me, not on social media, you can easily get my phone number. You see it on the screen right now, but you can get it. You can get my email address. Just go to employmentlawyer.ca. Again, I'll give that to you again, employmentlawyer.ca. That's the website. You have all the contact information there. First of all, you can learn a lot more about employment law, about workplace rights, but you can also get email, phone numbers, so we can connect. So if you don't necessarily get on air today with me on social media and you want to have a private chat, not a problem, we can do that. Or maybe we talk a bit today and you want to follow up with me, just go to employmentlawyer.ca. Today's session, like every session, is about you. It's not about me. It's about what you want to know, about your problems, your concerns, the difficulties and the struggles that you may be facing in the workplace right now. Remember, the reason we do this is because the law is actually quite good. It's actually robust, and it's there to protect you. Many individuals don't necessarily understand what the law is and what their legal options are. Well, I understand, I know, and that's why I'm here to tell you what you need to know. Take advantage of that. We have plenty of time. Ask your questions. I'm live right now for one purpose and one reason, and that is to answer your questions. And then in between your questions, as I'm waiting for them today, again, don't be bashful. Let me kind of clear some of my inbox here. Hopefully you guys can see me. I think I have a bit of something came on the screen. So Steph, if you're there, I think we have a slide up on the screen right now. Maybe you can get rid of that. There we are. So in between your questions, let me answer some email questions that I've received, but ask your questions as well. So an email I've received from Paul, who says, my boss just told me that I have to get a COVID vaccine in the next 2 weeks or I'm out of a job. Is this legal? Now, I'm sure many of you have wondered the same thing. I know I've been getting a lot of questions in the past number of days and weeks asking about vaccines. So let's answer Paul's question. Paul was given this ultimatum, get a vaccine in 2 weeks or else. Well, let's be very clear. His employer, your employer, does not have a right to force you to get a vaccine or to threaten you if you choose not to get a vaccine. An employer cannot make an employee be vaccinated. It is ultimately a personal decision. Of course, there are good reasons as to why someone should be vaccinated, but ultimately it is your decision. It is your right. Your employer cannot punish you. Your employer cannot let you go, threaten you, reduce your hours, put you on a layoff, you name it, because you've chosen not to be vaccinated. Okay? Ultimately, it's your decision. And an employer that, despite what I said, decides to punish someone, that's a breach of the Human Rights Code, potentially, breach of privacy legislation. It's wrong, it's illegal. So if you're ever in that situation, talk to your employer. If you can't get it resolved, talk to me. Give me a call, send me an email. You can go to employmentlawyer.ca to get all that information. But don't forget that despite what you may be hearing about what's going on south of the border, here in Canada, doesn't matter what province you're in most cases, an employer cannot make you get a vaccine. Now, there may be some exceptions in long-term care homes, in hospitals, where there's very sensitive or it's a sensitive situation. There's people that are potentially medically compromised. So to protect them, an employer may have more flexibility. But for most people, you cannot be made to be vaccinated. Okay, so very important to keep that in mind. I know a lot of people have been wondering about vaccines, so there we are. There's your answer there on the vaccine front. So, hey, I'm live. I see some questions coming in right now. Let's answer them. Let's ask them to give me an opportunity to help you. So I'm going to start answering questions. First question, I believe through YouTube from Razor Sharp. If I'm still on a layoff, can I do anything about it now that the IDL is going to September? I can't afford to stay on a layoff. Absolutely. This is one of the most important questions that I've been getting. I've been getting it a lot. Your employer, despite the infectious disease emergency leave, the IDL, does not have a right to keep you on a layoff. You can choose to treat this as a termination, Razor Sharp. You can choose to say, I'm not accepting it, and I want my severance. So you can choose that today. You don't have to wait till tomorrow. You don't have to wait till July, to August, to September. You can do that right now. In fact, I would suggest you should do that because I think enough is enough. It was extended several times. Now it's been extended till September. It could be extended again. But that's only if you choose to accept it. You also have the ability not to accept it and pursue your termination rights. If that's what you want to do, Razor Sharp, you're talking to the guy that can do that for you. Contact me off air and let's have a chat about what you're owed and how to go about getting it. It's not a complicated process. So Razor Sharp, if you want to get severance, if you want to say enough is enough, I'm not waiting, I can't afford to wait, contact me through employmentlawyer.ca. You also see my number right there. And then we'll speak soon about it. That's a great question. Same for you. If you're on a layoff right now, you're hoping to get back to work and that's not happening, you can treat that as a termination if you choose now, okay? Contact me and we can make that happen. Thank you very much for that. Next question, ask yours as well. You see how simple it is? You just get a question, I answer it, easy. Next question from Ahmad. I have a human rights claim in process with my ex-employer. I gave my manager as a reference from that company as we had a great relationship, and she said I could use her at any time. Turns out she gave a bad reference, although I had an excellent track record costing me the new job. So Ahmad, this may not actually be a human rights violation. It's only a human rights violation if she gave you a bad reference because of your age or ethnicity or race, sexual orientation. But if she simply lied to you and told you she'll give you a good reference and gave you a bad reference, then that's not a human rights violation. What that may be is defamation. So you may well be in the wrong legal process. It may not be a human rights issue. But I've done many cases like this, and it could be a defamation situation. She said bad things about you that are not justified because that you lost something, you lost a new job. You may have recourse, legal recourse. It could be something else as well. It could be something called interference with contractual relations, where she did something to prevent you getting a job. That means that you may be owed compensation. So Ahmad, I think rather than proceeding with a human rights claim where, again, unless this was discriminatory, there may not be a case there. You want to talk to me, and we may want to talk about defamation here, okay? So by all means, if you want some help with this, let me know. We can connect. You go to employmentlawyer.ca. Again, employmentlawyer.ca. I can help you and we can discuss it further. Thank you for that question. Really good one. Again, see how easy it is. Ask your question. Bunch of people watching, so ask away. Next question from Facebook from John Michael. Just wondering, after mediation, how firm is the 30 days to pay any monies agreed to? So if you have a settlement agreement that requires a company to pay you monies within 30 days, if they don't, you can go to court for breach of the settlement, okay? Unfortunately, that's a process that also takes the time. It could take 30 days to get there. But if you have a good lawyer, that lawyer can put a lot of pressure on the company. But you can't go into the company with a baseball bat and threaten them. You have to go through the legal process, which means you have to bring a motion to the court. And to schedule things in court takes some time. You can't call the court today and schedule something for tomorrow. It's going to be probably a few weeks out. And then there's a court order once you're in front of a judge saying, hey, company, you better pay or else we're going to do all kinds of things, charge you penalties, fines, etc. So that's what you got to do. And if you have any questions, any help, you know what to do. Reach out to me through employmentlawyer.ca. So Ahmad says, okay, good, that the human rights issue is a different issue. So Ahmad, good. Hopefully I answered your question. And that's actually important. If your employer badmouths you, okay, that's defamation. You can't be badmouthed, especially if it's false. Listen, if someone says Lior is a liar, well, if Lior is really a liar and the person can show that Lior is a liar, then it's not defamation. But if someone says Lior is a liar and that's false and there's no proof or evidence, that's defamation, right? So defamation is something that is a big deal. Your reputation is the number one thing that you have, your good name. So if someone hurts that, you may want to do something about it. So thank you very much for those questions. I'll continue answering. Ask your questions as well. We're live right now, right? Live. So ask your question. There's plenty of time. Next question from Kevin on Facebook. If I was off on a leave of absence for health reasons, do I need to show a medical note? Or if someone has COVID and I'm caring for them, can I be fired when I return to work? So, Kevin, if you're ready to come back to work, you tell your employer that. If they ask for a doctor's note clearing you, then you have to get it. So it's up to the company. You can simply say, company, I've been cleared to come back to work. I'm ready to come back. If they're okay with it, great. If they say, well, we need a doctor's note clearing you, we need to see an actual doctor's note, then you need to get a doctor's note. Now, in terms of if you're caring for someone that has COVID, if it's a close family member, parent, child, grandparent, then no. You cannot be fired for that. You're entitled to take a leave of absence, unpaid leave of absence in that situation, and you cannot be fired. Now, if you're caring for your good friend, that's obviously very nice, but your employer does not have to keep your job open in that situation. So it has to be a close family member. And then, yes, your employer would have to keep that job open for you. You cannot be fired. And that's absolutely fine. Obviously, if a company does let you go, it's a problem. You say here it's a parent, Kevin. You're allowed to care for your parent that has COVID-19. Okay, and you have to be given what I call a job-protected leave of absence. That means that your job is protected. Your job is still going to be there waiting for you by law when you're ready to come back to work. All right. So your employer may ask for a doctor's note on that front. That's okay. But if there's any trouble, any problems, if they threaten you, if they let you go, if they say you've resigned, you know what to do. You contact me. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You'll see all the contact information there, phone, email, fax, whatever you want. It's all right there, and you can reach out to me privately. Same with you. Ask your questions. As we're waiting for the next question, let me tell you about another tool that you absolutely have to know about, and that is the Pocket Employment Lawyer. Okay, Pocket Employment Lawyer. Well, the nice thing is the website is also very simple, pocketemploymentlawyer.ca. You see it right there. So what is the Pocket Employment Lawyer? Well, it's like having your own lawyer with you at all times for free on your smartphone, your desktop. It may be difficult to fit your desktop in your pocket, but it still works. So what happens when you go to pocketemploymentlawyer.ca? Well, number one, we have our severance calculator tool there. So if you want to know now, in seconds, how much the company owes you if you lost your job, if you're going to lose your job, or if you're just curious, you just go to pocketemploymentlawyer.ca. All right, very simple. On the other hand, there's other things there you can do as well. You can find out if the company had just cause to let you go. You can find out if you're an employee or an independent contractor. You can find out if your case, your matter is considered harassment or discrimination. More things as well. It's like having me with you at all times, pocketemploymentlawyer.ca. If you have a legal issue, if you're struggling with a problem, changes to your job, being let go, discriminated, harassed, whatever that issue is, just grab your smartphone, go to pocketemploymentlawyer.ca, and you'll get an analysis of your case, your situation, your rights. We're using technology here. It's pretty awesome. So check it out, pocketemploymentlawyer.ca. Kevin has a follow-up question. Do benefits also stop when I'm on a leave of absence? So your employer would not have to continue benefits during that time. Okay, most employers would though, because it doesn't make sense to turn off and on the benefit plan, but they would not have to. Okay, so hopefully that helps there. If you have questions, guys, we got plenty of time, easily 15 minutes, so ask away. And in between your questions, as I'm waiting for the next one, let me go back to my mailbox here and answer some emails that I've received. From Dana. Dana wrote and asked, I've been off on a stress leave for 2 months, but I don't want to go back to work because I'm afraid of how I will be treated. What do I do? So, Dana, obviously you have a right, like everyone else, to be treated fairly, properly. You have a right to a healthy and supportive work environment. That's a right that we all have. So, if you're being harassed or mistreated or bullied, that's illegal. Forget the fact that it's inappropriate. It's actually illegal. The thing is always, how do we prove? How do we show that you're being mistreated? Because the people that mistreat you are not going to just admit it, as you can imagine in most cases. So how do we show that? Are there emails? Are there recordings? Are there witnesses that are willing to speak? If there are, then it's very, very easy. So if you can show already, Dana, that you've been mistreated, you may not have to go back there. We call that a constructive dismissal. You can leave and still get compensation from your employer. But that's if you can show that you've been mistreated. If you can't show, one idea may be to go back and start to document things. If someone does treat you badly, document it. Send an email confirming it. If someone says something that's inappropriate, send them back an email confirming what they said. Create that written record. And once you have it, then we can pursue a constructive dismissal. You also want to speak to HR in writing, put that in writing so there's a record of you addressing this issue with HR. So Dana, you can always just resign. You have a right to resign whenever. But if you want to get compensation because you've been mistreated, you're not just leaving because you don't want to be there, then we need to make sure we can prove it. Same with you. If you're being bullied, harassed, discriminated, mistreated, the question always is going to become, how do we show it, right? I believe you, always will believe you, but how do I ultimately show it to the world that that's what's happening? Can we document things? Is there a recording? So that's always an important question. If we have the ability to show it, these matters can be resolved on really good terms, and they're not very complicated. So Dana, hopefully that answers your question. So next question from YouTube, Unique. I think I'm pronouncing it correctly. I was working while disabled and tried to get a leave. Before approved, the pandemic came. We had a meeting where the plant manager told us Trump is closing the USA. Told to file for unemployment, but mine is being offset. So there's a few things to unpack here, Unique. First of all, I'm assuming you're in Canada. If you're in the US, I really can't help you. But assuming you are in Canada, the question becomes now, are you able to do your job? Not talking from a medical standpoint. Is your job available? Okay, can you do it, or is it impossible to do your job because of COVID-19? If you otherwise could do your job, but your employer decided to put you off on a leave, you can treat this as a termination of your employment. Okay, your employer should have you working. If you can't work for medical reasons, then you stay off on a medical leave, and when you're ready to come back to work, if your employer at that point doesn't take you back, that's a termination, potentially a human rights violation, and your employer would owe you compensation. So again, first question is, can you be working right now if you were able to? Or is it impossible? The employer has to be shut down. So if the company has to be shut down, they have no choice by law, by regulation, by government action, they have to shut down. If that's the case, there's not much that can be done right now. But if they can operate, but they choose to have you on a layoff instead, that's different. They're not allowed to do that. Okay, hopefully that answers the question, Unique. If there's something else that you're wondering or that I didn't necessarily understand, by all means, please ask. I'm still here. You got plenty of time. Happy to do any follow-up questions. I see there's a question coming in from CD on YouTube. I only have the first sentence right now. With the company for 17 years. That's all I have. Feel free to ask the rest of the question. In the meantime, as we're waiting for questions, ask yours, by the way, guys. You see how simple it is. Live, you're live. Let's make sure that you leave here with answers to your questions. Okay, Unique says, they terminated me 4 days before I was due to return. So the question then ultimately becomes, are they able to operate, or are they forced to shut down? If they terminated you, you're owed severance. And depending on how long you've been there, Unique, that could be as much as 24 months. It could potentially also be a human rights violation. If they let you go because you're on a medical leave, because you have a medical issue, that could be discrimination. So there's a lot to talk about, Unique. So I want to connect with you as soon as possible. Don't wait. Let's connect even later today. Just go to employmentlawyer.ca. Again, employmentlawyer.ca. You can have my phone number. Just give me a call, or email address. You see it right there, right there. You can send me an email there. But there's severance issues here, Unique. There's human rights issues potentially. So we really need to discuss this. I wouldn't hesitate. Okay, call me today, not tomorrow. Let's deal with this right away. Next question from KM. Can my employer force me to vaccinate? So we answered that earlier on the segment. So let me remind everyone, no, your employer in most situations cannot force you to be vaccinated. It's a personal choice, and you cannot be threatened or punished if you choose not to be vaccinated, okay? So now there may be some exceptions. If you're working in a long-term care home, or if you're working in a hospital, your employer may have more flexibility and the ability to require you to be vaccinated, maybe. But in most cases and in most situations, no, it's a personal decision. If your employer is threatening you or putting pressure on you, KM, you want to give me a call. Okay, let's deal with that properly. But no, your employer does not have the right, the legal right, to force you, to threaten you, to make you get a vaccine. Personal decision, an important decision, and you have to make that decision on your own. Unique has a follow-up. They told us they would call us to return to work. They never called me. Well, then, Unique, you know what to do. As I've said, you reach out to me through employmentlawyer.ca. Dick Pants writes, not all heroes wear capes. I guess that's a compliment, so thank you, man. I appreciate that. Hey, we got some time left, guys, so please ask your questions. If you want to know about your legal rights, now's the time. So question came in just now from YouTube from CD. I was with the company for 17 years. I moved to a different department, and I was put on a performance improvement plan. I went on stress leave and returned after a few weeks, and I was terminated. What am I entitled to? So CD, the main factors that go into assessing what you're owed are your age, your position, and the length of your employment. So I already know you've been there for 17 years. I don't know yet your age, and I don't know the type of job that you had. But even given 17 years, you could be owed anywhere, frankly, from 15 to 20 months pay, okay? 15 to 20 months pay is what they owe you. I would be curious for you to tell me, CD, what did they offer you, okay? And the other concern I have is this. If you go off on a medical leave and then they let you go, that could be a human rights violation if they let you go because of your medical leave. So there's a lot to discuss here, okay? And you could easily be owed up to 20 months pay given all the years you've been there. Let me know what they got, what they offered you. And otherwise, CD, you want to reach out to me now, as soon as possible, okay? Employmentlawyer.ca, the way to reach out to me, phone number, email address. You see the right on the screen there, at the bottom of the screen, my phone number or my contact information, employmentlawyer.ca, phone number, email address, it's all there. That's all you need to remember, employmentlawyer.ca. Let's have a chat. We got some time, last 5 or 6 minutes, guys. Ask questions, don't be bashful. Next question from Matt on YouTube. What's the maximum time for a layoff to last? Well, that's actually a bit of a tricky question because that assumes that a layoff is allowed. Well, a layoff is actually not allowed. An employer does not have an automatic right to put you on a temporary layoff. In other words, if your employer puts you on a temporary layoff, Matt, you can choose now, on day one if you want, to treat that layoff as a termination of your employment. So you can do that now. You don't have to wait. So the only time we're concerned about deadlines is if you choose to accept the layoff. Right now, that layoff could last till September, another 8 months after that, potentially. That takes us, I don't know, to mid next year. But that's only if you choose to accept that layoff. Otherwise, you can choose to treat that as a termination now. You don't have to wait, not another day, not another week, nothing. If you want to get your severance, if you were sick of waiting, tired of waiting, you know what to do. You reach out to me. I'll help you do it. That's what I do, employmentlawyer.ca. Okay, employmentlawyer.ca. Next question comes to us from Dinah. Hopefully I'm pronouncing correctly. On Facebook. Is an employer required to give a reason for termination with notice? No. In most cases, the employer is not required to give a reason as long as they either give sufficient notice or they pay enough pay in lieu of notice or severance. Then your employer doesn't have to give a reason. If they give a reason, it doesn't necessarily even have to be the right reason. They can give you a reason which is not actually true. The real question is, did they give you enough notice or severance? In 90% of the cases, your employer may not give you enough notice, in fact, not even close. So they don't have to tell you why, they have to pay you proper severance, okay? And chances are whatever they offered you is a lot less than what you're owed. Next question comes from CD, who follows up and says, 50 years old and I've been offered 18 months. So 18 months I have no problem with. 18 months is appropriate. By the way, as long as it's 18 months of salary and benefits and bonus and car allowance, in other words, all components of your compensation, not just your salary, has to be 18 months of everything. But the other thing that I'm concerned about, CD, is did they let you go because of the fact that you took a medical leave? If that's why, I'm not saying that it is, I don't know, just the timing kind of bothers me. If that's why they let you go, again, it's potentially a human rights violation as well. Happy to sit down and chat with you about this. If you'd like to do that, easy, employmentlawyer.ca. Diana says, yeah, it seems a little heartless that an employer can let you go with no reason. I agree completely. I'm not saying that's a good idea. In fact, I think that's wrong from an ethical standpoint. I think it's wrong from a business standpoint. But from a legal standpoint, it is allowed. An employer does not have to give any reason or to give the right reason. But the real question, you've heard the term wrongful dismissal. A wrongful dismissal is a situation where you're let go without proper severance. 90% of people, when they're let go, in fact, are wrongfully dismissed. Okay, 90%. So if you're let go, if we're going to line up 10 people that lost their jobs, even if they lost their jobs for a legitimate reason, out of those 10 people, 9 of them are wrongfully dismissed because they're not offered enough severance. Those are the statistics. Someone that could be owed 20 months is offered 6. You get the idea. If you want to know how much you're owed, you can call me, you can email me, but you can also go to pocketemploymentlawyer.ca. Again, pocketemploymentlawyer.ca to calculate your own severance in seconds. Seconds, free, anonymous, no names, nothing like that. Pocketemploymentlawyer.ca. Peter just posted a question. Peter, I'm not going to be able to read that on air here. It's going to take me a while. So if anyone else had asked a question before Peter, I can't see that question. Peter's question kind of pushed it down my screen. Feel free to ask it again in the last couple of minutes so that I can see it. Peter, the best thing I can say to you is, why don't we connect off social media, off air, and I can talk to you, I can help you, I can sit down and understand exactly what the issue is. I'm not able to read such a long posting at this time. CD asks, if it is a human rights violation issue, what's the maximum I'm entitled to? So, depending on the situation, it could be anywhere from $5,000 to $100,000, right? Depending on the situation. So I need to know more. That's why I want to sit down with you and find out a bit more about your job, the circumstances, the timing. That's why it's important that we have that chat. I had a question here from Kevin. Are you required to be fully vaccinated before I return to work? I don't have my first shot. So we've answered it a couple of times today, Kevin. Your employer cannot force you to be vaccinated, okay? Unless the government intervenes and says, employer, you have to have all your employees vaccinated. Unless the government does that, or public health, then your employer cannot decide to do that on their own. There's no right to do that. Kevin, if you or anyone else, if your employer is forcing you, threatening you, you know what to do. You call me, I'll help you, but you cannot be forced. So let's see, next question from Ray. Can an employer serve you a termination notice via email and on a statutory holiday? Not a nice thing to do, right, Ray? Not at all. But legally, yes, they can. So not a very nice thing to do, but not nice, but unfortunately legal. I think I am caught up here with questions. If you have other questions, our session is now coming to an end. Don't worry about it. I'm not going anywhere. I'm just shutting off my camera here, but I'm getting back to work to answer questions by email, to speak to people on the phone. We have a whole team doing just that all the time around the clock. So if you're in that situation, you know what to do. employmentlawyer.ca to continue that discussion. I'll be back next week right here, same time, same place. Please don't wait a week. Makes no sense for you to wait a whole week to speak to me again. So if you're, by the way, Matt, yes, you're entitled to overtime. I just see the question. Otherwise, we're done here. Thank you very much for joining us. employmentlawyer.ca, first place you go to. We'll be back next week. Take care of yourself. Try to enjoy some of the nice weather. We'll talk to you soon. Please take